Hello, this is Usman Malik of LondonLawTutor.com. It has been quite some time since we did our last introductory lecture. So today we are going to do this on a very intriguing and intellectually rewarding subject of jurisprudence and legal theory. Now, any of you that are doing the University of London's International LLB would be required to take this module, jurisprudence, in your final year. And many of the University of London law schools here in London, like King's College London, University College London, etc., require you to take jurisprudence as a mandatory module as well. Why is this module important? Well, because it makes you understand more wider issues surrounding the evolution of legal systems and legal debates. It also makes you understand the nature and the concept of the law as it has evolved over a period of time by looking at the different academics that have helped this evolution, using their debates on issues of importance. So, there are essentially, in the basic question, what is law, different schools of thought and what the study of law should involve. So, for example, the law is a command of the sovereign backed by the threat of sanction. Now, this was said by John Austin, who based his theories on the work of Jeremy Bentham. And then these theories were furthered by Professor H.L.A. Hart. Now, it is crucial to understand that this is an introductory lecture and this subject goes extremely deep into the intellectual debates that form the fundamental of this module. And this module helps you think outside the box and improve your lateral thinking skills by enabling the student to think critically about the different articles they will read. So, for example, there are natural lawyers and positivists. The positivists mainly argue that the study of law should not involve, doesn't necessarily need to have a moral content, whereas natural lawyers would say, no, morality and the science of law, jurisprudence, are linked together, and it is imperative that we understand that if a law is so morally reprehensible, then it is not law at all. It needs to have a minimum quality in terms of having a legal conscience, for example. So Nazi law under Hitler would not be considered valid law by those who are natural lawyers, whereas positivists would say that it is a legal system even though it is an evil legal system. And this formed the subject matter of the famous Hart and Fuller debate, where Professor Lon Fuller was arguing from the natural law perspective and Professor Hart was arguing the positivist angle. Now, moving on, one of the important things to understand is that there's an article known as Taking Rights Seriously by Professor Ronald Dworkin, who was not a natural lawyer nor a positivist, so he was neutral. And he writes about the interpretive nature of legal argument, that in areas where the law is gray, it does not have a clear precedent, then we as lawyers need to take the judges by their hand and show them that this is the correct side. Our client's side is the correct, their perspective is the correct one, and hence the judge should decide in our favor. So that's the interpretive nature of legal argument. This is how lawyers and judges help create new law where there's not a clear precedent. Another very interesting read is Professor Lon Fuller's Legal Fictions, where he talks about the fact that contracts don't grow on trees. We as human societies have invented them in order to give our promises between each other the force, the backing of the law. And another famous article known as the Spelunkian Explorers written by Professor Lon Fuller as well, which helps us appreciate the nature of law. So for me as a positivist, I might decide something differently than you who are natural lawyers. And if you read these articles, you will come to understand how useful this area of law is, and how it does not have a syllabus or case intensive studies like equity and trust or contract law or tort law, but it is very useful for you to understand how the law develops and evolves. For example, to conclude, Baroness Hale, ironically a woman sitting in the House of Lords, now the Supreme Court, in Stack and Dowden in 2007 said, the patriarchal approach of Lord Bridge in Lloyd's Bank and Rossett is outdated now. So essentially saying that the pendulum has swung from a patriarchal approach in 1986 to a more, feminist-based approach in 2007, where the deserted wife's equity is developed to such an extent that she will get a share in the house because she enabled the husband to work and pay the mortgage payments, etc. So I hope this has been useful. I mean, I don't want to pack too much information in one podcast, but it is a very intellectually rewarding and fruitful area of law. Thank you very much for listening.